Hi, I'm Franco Ferrari. I'm a professor at NYU School of Law, where I also direct the Center for Transnational Litigation, Arbitration, and Commercial Law. Also, I'm a member of the Academic Council of the ITA, which is hosting a series of videos entitled, What Am I Working On? Today, it is my turn to tell you what I'm working on. Together with Dr. Friedrich Rosenfeld, a partner at Hanefeld in Hamburg and global adjunct professor at NYU's Paris site, I'm writing a paper on the limits to party autonomy in international commercial arbitration. The topic of the paper is one that I have been doing research on for some time. In 2016, I edited a book with the same title, to which a diverse group of colleagues contributed by submitting amazing papers. Each contribution addressed a specific aspect of the overall topic of limits to party autonomy. The paper I'm co-authoring with Friedrich Rosenfeld is different, as it takes a much broader view regarding the topic. Still, the starting point of the two publications is the same, and unsurprisingly so, namely the fact that arbitration is considered a creature of contract and therefore an expression of party autonomy. Some commentators even consider party autonomy to be the backbone or bedrock of international arbitration. This liberalist thinking is based on the premise that arbitration is a dyadic process between two rational parties that rests on parties' delegation of adjudicatory authority to an arbitral tribunal through an exercise in party autonomy, namely the arbitration agreement. This party autonomy is not only the source of any arbitral tribunal's adjudicatory authority, it also allows the parties to decide how that adjudicatory authority is to be exercised. In other words, party autonomy allows the parties to shape the arbitration in a way that best fits given facts and circumstances. And it is this autonomy and the promise that parties to international arbitration are free to control their process that have contributed to the success of arbitration. Without party autonomy, it appears arbitration would not be what it is, and much of its appeal would be lost. However, a closer scrutiny shows a different picture. Neither are the actors who may potentially be involved in arbitration proceedings by definition rational agents, nor is arbitration a process involving only the parties in dispute. Arbitration creates a web of relationships involving the parties, the arbitrators, arbitral institutions, and the public at large. While these have interests that may at times overlap, they diverge in others, thus creating tensions that at times are solved only by limiting party autonomy. The paper Friedrich and I are authoring develops a taxonomy of these limitations to party autonomy that reflects the diverging interests of the various stakeholders affected by the arbitral procedure. In the paper, we submitted there are limitations to party autonomy in the interests of the parties themselves, the public at large, the arbitrators, as well as the arbitral institutions. By acknowledging these limitations, which may also, of course, be imposed in the interest of more than one stakeholder at any given time, we do not wish to downplay the merits of party autonomy or depart from the liberalist tradition. Quite to the contrary, it is our position that a clear understanding of the limitations to party autonomy is necessary to protect arbitration against, among others, legitimacy challenges and to uphold its role as the primary instrument for resolution of business disputes. Ultimately, the limitations to party autonomy also ensure that arbitration can persist as a viable system of dispute resolution. I hope that this short abstract will get you to read the paper once it will have been published. Thanks and stay well.